UN High Commissioner has established the CHR Sri Lanka Accountability Project with a team based in Geneva. The investigative mechanism will collect and preserve evidence of human rights violations and related crimes, as well as develop possible strategies for future accountability processes, advocating for victims and survivors, and supporting judicial and other proceedings, including in member states with competent jurisdictions. The Office of the High Commissioner will report to the 49th session of the Human Rights Council in September 2022 on the implementation of Resolution 46.1. The objectives of this roundtable are firstly to unpack the investigative mechanism for Sri Lanka and its potential to increase accountability for the violations and crimes committed in the final phase of the conflict in Sri Lanka. Two, to examine potential collaboration between the Office of the High Commission mechanisms and UN special mandate holders, civil society and member states to strengthen the mechanism and facilitate engagement between member states to support universal jurisdiction cases, sanctions, vetting, and truth recovery processes. And thirdly, strengthening civil society in Sri Lanka and abroad by advocating and contributing to innovative measures that will increase accountability for violations of human rights and international humanitarian law, as well as other crimes. We have a very distinguished panel here with us today, and I will very, very briefly introduce them at this stage. They have very distinguished CVs, but we don't have enough time to go through all their accomplishments. So briefly, I'll introduce the following people. We have, talking on transitional justice, Pablo de Greef is a human rights activist and former special rapporteur on the promotion of truth, justice, reparations, and the guarantee of non-recurrence. He will speak about his experiences of transitional justice in engaging with the government of Sri Lanka and the lessons learned. He will also discuss potential actions that Sri Lanka Accountability Project can build and how civil society can assist with these. On the issue of conflict-related sexual violence, we have, Priya Gopalan is a lawyer who specializes in international criminal law, human rights law, and gender. As a former gender advisor at the OISL and legal advisor for sexual and gender-based crimes in IAM Syria International, impartial and independent mechanism, she will reflect on the potential of the mechanism to deal with gendered crimes, including conflict-related sexual violence. On the issue of sanctions, we have Amanda Garamani, who is an international lawyer with expertise in international criminal law and transitional justice. She will explore the potential for sanctions to move the agenda forward for victims, as well as asking what the current obstacles are to NGOs making successful submissions. On the issue of universal jurisdiction, we have Ambassador Stephen Rapp, an American lawyer and former United States Ambassador at Large for war crimes issues in the Office of Global Criminal Justice. He will explain what Sri Lanka can learn from the experiences of Myanmar and Syria when looking to frame universal jurisdiction cases against perpetrators. And for the Office of the High Commissioner for Human Rights, we have Livia Cosenza, the Desk Officer for Sri Lanka, and Anna Katuru, the legal advisor for the Office of the High Commissioner in Sri Lanka Accountability Project. And they will provide an update on the Office of the High Commissioner's implementation of the Human Rights Council Resolution 46/1, including the Sri Lanka Accountability Project. And from Sri Lanka, from the Sri Lankan perspective, we have J.S. Tisanayagam, who is an award-winning journalist and political commentator who writes on Sri Lanka and South Asian politics. He will respond on what is appropriate to assist Sri Lankans and what will help move accountability forward. And then we have the chairperson of the roundtable, who will be speaking on vetting and screening as well, the ITJP Executive Director, Yasmin Suka, who is one of the world's leading transitional justice experts and human rights defender. Yasmin will look at the experience of Sri Lanka as a test case for vetting and screening UN peacekeepers. What 3 steps would give credibility to the process, and what is the impact on militaries? So without further ado, I want to hand over to our chairperson of the roundtable, Ms. Yasmin Suka. Thank you.
Thank you, Hanif. Good morning to those of you who are just in the process of waking up. Good afternoon and good evening. As Hanif explained, we have a very distinguished list of panelists today who will all be providing a 5-minute input on the topic that they will address. And that will be so that we can spend a good amount of time actually having a discussion. To let you know, the event is being recorded and live streamed on the JDS Facebook page in English and Tamil, and of course on the ITJP YouTube channel as well. You also have a button at the bottom of the screen for interpretation, which will be done simultaneously, and you can opt for whether you want that in English or in Tamil. If you would like to ask a question, you could use the Q&A function for questions, or you could also text them on Facebook. And so we're going to try and ensure that this is very, very interactive today, in as much that one can do on a webinar of this nature. So without much ado, I'm going to call upon Pablo de Greve to begin our proceedings today. Pablo, over to you.
Thank you very much, Yasmin, and congratulations to the organizers. It's always an honor to be with my fellow panelists. I am going to be brief because I was asked to talk both about my experiences dealing, I want to make clear, with the previous government on transitional justice issues while I was UN Special Rapporteur for Transitional Justice. I think that the main lesson that I learned was one, as usual, that governments are not monolithic. There are always both pockets of goodwill, but pockets of very, very deep resistance. And perhaps the overwhelming blockage that I found in my dealings with the government was the reluctance on the part of both the president and the prime minister to really appropriate the agenda of transitional justice. I think that they left it hanging in midair, never fully supporting it, never coming out completely against it, just leaving it as a hanging target for people to attack, and therefore doing what many governments had done previously in Sri Lanka, which was just enough that they thought that they would be satisfying international public opinion, but never fully complying with their obligations. And I regret to say that what we are seeing today is even worse. So there is news about Sri Lankan diplomats doing the rounds in different parts of the world with a view to the March meeting of the Human Rights Council, trying to convince different governments that Sri Lanka is in fact fully complying with international obligations, and even having the goal to say that were it not for international interference, Sri Lanka would be able to spend its meager resources on fully satisfying the claims of victims. I have to say, I never saw that in my dealings with the previous government. There was some willingness on the part of some to establish mechanisms such as the Office of Missing Persons, the Office of Reparations, and then newly established Office of National Unity and Reconciliation that didn't have a completely clear agenda. And I am afraid that the agenda that it has now has very little to do with accountability. Since I have only 2 minutes left, the second thing that I was asked to do is to give 3 recommendations about what can be done to support the new mechanism. And I'm going to spread them not just to Sri Lankan civil society, but to the following stakeholders. I think that UN special procedures can contribute a lot, provided that they systematize their work much more than they have do it up to this point. I think that the UN at headquarters level can do a much better job at pushing Sri Lanka in a positive direction. It was the silence of headquarters in New York at different points of the Sri Lankan crisis is something that is very difficult to explain and something that certainly doesn't help too much. And now finally to civil society in Sri Lanka, which of course is far from monolithic. I think that Sri Lanka misses networks of civil society organizations, despite the fact that it has brilliant individual NGOs. They do not network very well together. I think the majority population needs to understand that access to justice and the security cannot happen while those systems are largely monoethnic. And I think that all the effort in the previous Rajapaksa government to say victims are not interested in accountability, they are interested in economic development. It was false then, demonstrably, and it is false now, and it will not work. The claims to justice of victims need to be taken seriously. And I will stop here because I'm out of time. Thank you.
Thank you, Pablo. I think you really managed in your 5 minutes to really touch on a range of issues, which I hope we can pick up in the discussions. And there's much applicable to Sri Lanka as there are to many other post-conflict countries as well. So thank you very much for that. Priya, I'm going to turn to you next.
Thank you, Yasmin. So I'll share briefly in my 5 minutes some thoughts on the new UN mechanism and how it might address impunity for conflict-related sexual violence in Sri Lanka. Now, by way of background, one of the most disturbing findings of the OISL report, that is the OHCHR investigation on Sri Lanka, in which I was involved in, one of the most disturbing findings of that entity was the prevalence and extreme brutality of sexual violence in Sri Lanka. And with that backdrop, let me turn to some of the key features of conflict-related sexual violence in Sri Lanka. I'll start with the types of acts. In general, sexual violence was perpetrated as part of systematic torture that was perpetrated in state-run detention facilities. And this included rehabilitation centers to which LTT cadres were sent to after the LTT defeats in 2009. But aside from this, what one might term stereotypical example of sexual torture, I think in the Sri Lankan context, it's important to remember that a varied type of sexual violence was perpetrated. For example, there were cases reported of female family members who were subject to rape or sexual violence, or when they went to inquire about male relatives or perhaps husbands, brothers who were missing, when they went to a detention facility to inquire. So it was part of the inquiry process. Another term that often comes up in the Sri Lankan context is sexual bribery. And this is linked to the large number of female-headed households that are found in parts of the country where women have lost their husbands and find themselves heading their families and are reported to have to engage in sexual conduct and forced prostitution to secure basic living needs. So these are some of the types of sexual violence. And now I'll turn to the profile of the survivors. Again, as we know, survivors are not a homogeneous group. And in the case of this conflict, we have complex profiles of survivors. They could be established, long-standing LTT carders, or they could be individuals with merely perceived links with the LTTE. They could be individuals who had been abducted by the LTTE to fight as child soldiers. So they could be young, old, male, female. Their role in the conflict could differ. And if we're interested in accountability, we need to understand the type of harm that the individuals experience. And here, I hope these examples highlight the significance of intersecting identities, so the different experiences and identities of survivors of sexual violence. And turning to another point, so far, I have talked about the differences in terms of the types of acts and the complex profiles of survivors. Now, I would like to focus on what unites many survivors of sexual violence, and that is the cultural significance of this violation. Now, in the Tamil context, and in my opinion, more so than in other cultural contexts, at least in the conflicts I have worked in, the issue of stigma and so-called shame imposed by society is internalized very deeply by survivors and can be all-encompassing. And for those of us who work with Tamil survivors in this conflict, we can all attest to the frequency with which suicide is contemplated and indeed attempted as a response to stigma associated with sexual violence. So when we're dealing with this issue of sexual violence and stigma, one cannot avoid the question of denial of these crimes. I believe other speakers are going to speak to the issue of denial more broadly. I would just add that in relation to sexual violence, the issue of denial is far more pronounced for reasons of stigma and taboo. And the issue of denial is a particular issue when it comes to men and boys who are survivors of sexual violence. And indeed, in this conflict, one of the findings of the OISL inquiry was that men and boys were as likely to be survivors of sexual violence as were women and girls. So that's an important point to note. And I see that I'm running out of time, so I will just turn to my final point. Simply to say that documentation is possible. We have seen the UN engage in it. ITJP has done so, but critically in terms of documenting, in terms of creating a safe environment for survivors to speak, two aspects are important. That is the physical safety relating to survivors who come forward, particularly significant in a conflict where reprisals are a common feature. And secondly, the psychological safety of survivors, that is adopting a victim-centered, trauma-informed approach when interviewing, and also post-interview, what sort of measures are put in place in terms of the referral systems, in terms of ongoing psychological care for those survivors who willingly come forward to speak. I have many more things to say, but I'll leave my remarks at that. Thank you very much, Yasmin.
Thank you, Priya. And I know that, I mean, from the outset of this conflict, denial has probably been the key characteristic, certainly on the part of the government and the military forces. You will recall that almost from the outset, they talked about mounting a humanitarian mission to rescue people, when in fact they were responsible for an enormous amount of targeted killings. But that's an issue we can come back to. Amanda, your turn up, and we take a different pathway to what I would call new forms of accountability. Over to you.
Thank you, Yasmin. Yes, I'll be speaking very briefly about the human rights sanctions regime and whether there's a role for this new OHCHR mechanism to engage with these sanctions regimes and how that fits with the role of states and civil society in this process. So perhaps I should just briefly explain the human rights sanctions regime, including both the opportunities, but also some of the flaws with the regime as it stands. And being a Canadian lawyer myself, I'll refer to Canada's Magnitsky Act as an example to illustrate my points. So the human rights sanctions regime is not a legal tool, but rather a political and diplomatic tool to exert pressure on foreign states and members of foreign governments to align their conduct with human rights norms. If an individual is listed under a human rights sanction, they can be barred from travel to a country, their financial assets may be seized, and they may be deprived from any future financial or commercial dealings in that country. Now, this tool has become more popular over the last few years because of the lack of accountability through other forums, including judicial forums. And as I believe Stephen will be speaking about later, one of the prominent accountability tools of the last decade has been universal jurisdiction investigations and prosecutions. But these cases are few and far between because they are very costly and they're quite complex. So for example, in Canada, we've only had 2 actual prosecutions under universal jurisdiction in the last 20 plus years. And so advocates and activists have turned to sanctions as an opportunity to get some form of justice, even though the remedies available under this pathway are not necessarily the most satisfying. Nevertheless, to many of the victims that I've spoken to and that I've worked with, it's still better than nothing, and it does have a symbolic weight as well. However, because of the novelty of these regimes, there are still some significant flaws that need to be addressed by the states who have enacted these statutes. First, there's a lack of transparency around the process for making submissions, including who has standing to make a submission, which department or body actually reviews and evaluates submissions, and what criteria they use for making these decisions. And there's also very little information about the evidentiary threshold for sanctions designations and whether there's a review or appeals process after a decision has been made. So this makes it very difficult for civil society to engage directly with the sanctions regime and to do so using standards of evidence that meet the necessary threshold for a designation. Second, there are serious concerns about a lack of due process, and these are concerns that I also harbor. And this is very much linked back to the lack of transparency around decision-making and evidentiary burdens. So to go back to the question of what role the Sri Lanka Accountability Project can have, I think it can play an important role in compiling strong, verified, and corroborated evidence against war criminals and human rights perpetrators who are or who may be targeted for sanctions. Through a robust methodology, the OHCHR mechanism can provide an additional layer of credibility and corroboration to strengthen the evidence and information that is being collected by civil society. And at the same time, there's a role for states who have legislated these sanctions to improve the way they function and to provide greater transparency. And states can also better cooperate with each other and share information and evidence for the purpose of a sanctions designation. As an example, Shivendra Silva was sanctioned by the United States in 2020, but Canada and the UK have not yet followed suit, despite the fact that the evidence collected against him for his role in the Sri Lankan war, which presumably is the same evidence that the US used for the designation, meets the criteria under both the Canadian and the British statutes. So if we want these sanctions regimes to be effective, we have to ensure that they're implemented using a human rights-based approach, which means transparency and due process need to be strengthened. And we need to ensure that they're accessible to civil society and international bodies that collect and preserve information so that sanctions can be considered a viable accountability pathway. Now, there's just one last point that I'd like to make, and this is directed mostly to civil society. The sanctions regime is one of many tools for accountability, but it's important to note that some tools can be mutually exclusive. So it's important for members of civil society to have a clear accountability strategy and to use the tools that will serve that strategy. For example, going back to universal jurisdiction cases, these cases offer an opportunity to criminally investigate and prosecute war criminals. However, one of the requirements under many universal jurisdiction laws is that the perpetrator must be on the territory of the country that is planning to prosecute. So we cannot use both the sanctions regime, which bans perpetrators from traveling to a country, in conjunction with universal jurisdiction, as they undermine and counteract each other. So I'll leave it there for the sake of time, but I'm happy to delve deeper into any of these topics in the Q&A.
Thank you, Amanda. It's, I think, another important accountability process going forward. And it would be useful to hear from the accountability program at some stage about the recommendations that you're making. I'm going to deal very briefly with the question of vetting and screening. As you know, Sri Lanka was required by UN Resolution 30/1 in 2015 to vet and screen public and security officials. And in fact, this was quite a lot of work that was being done in terms of the technical assistance that was provided by the Office of the High Commissioner for Human Rights. And so following on from the OISL inquiry, the UN was required to use the vetting and screening process, particularly in respect of Sri Lankan troops as peacekeepers. And in terms of the pilot they initiated, they also collaborated in supporting the local National Human Rights Commission, who were intended to carry out the initial vetting and screening. And it was hoped that by supporting this process with a second layer in Geneva, that one would actually produce a new model that could be rolled out to other countries. And I think one of the most important elements was, of course, building a national component to the vetting and screening process, which would also then be applicable to other public administrative processes. Now, of course, the threshold here was the question of risk and what risk would be posed by allowing people who had some kind of allegation that they were implicated in the final phase of the war, in allowing them to participate in peacekeeping. Another factor included whether they were part of the 134 members of the Sri Lankan contingent that had served in Haiti when troops were repatriated following credible allegations that between the period 2004 to mid-October 2007, they had sexually exploited and abused at least 9 Haitian children. The problem, of course, came with a complete breakdown in the process when the government itself deployed the first batch of peacekeepers without actually waiting for the Human Rights Commission to do the clearance. And this, of course, then resulted in the UN suspending the process of deploying peacekeepers for a whole year, while new procedures were then going to be put in place. Of course, in 2018, based on open source research that the ITJP conducted, we also ensured that the UN was able to repatriate the Sri Lankan contingent commander in Mali because he had misled the UN on his form about his own involvement in the war. Another form, of course, of the vetting and screening that really was problematic was that in August 2019, the Good Governance government appointed alleged war criminal Shavendra Silva, who had also been named in the OISL report. And this triggered widespread condemnation by the UN, the European Union, and of course, the United States. And while the UN peacekeeping unit promised to suspend deployment, they did, of course, say that it would only be where the UN was exposed to serious operational risks that they would continue to deploy peacekeepers. But in practice, nothing actually happened. And the UN continued to deploy the same numbers of Sri Lankans, including to lower risk countries like Lebanon. And of course, what's really sad is that when you look at these troops deploying, they all salute Shavendra Silva in their blue berets. And in fact, what you see is a man who is being acknowledged by troops who are going to serve in the UN and who himself is an alleged war criminal before setting off for a war zone. And so I think what we need to understand is that if we're going to have vetting and screening processes in which you do have a local component, it's really important to check the independence and credibility of the national body. And of course, in more recent years, the High Commissioner for Human Rights has noted that the way in which you've had people who are closely connected to the government appointed to the commission, that it has, it lacks independence. And of course, Gunry, the oversight body, has also proposed a downgrading of the commission to B status. And this is a considerable setback for Sri Lanka. In terms of diplomatic vetting, we've also seen 3 Sri Lankan defense attaches sent post-war to the United Kingdom, and these have been really problematic. You've also seen Shivendra Silva serve as the deputy permanent rep at the UN. You've seen Jagath Dias, another commander, serve in Germany and Switzerland and the Vatican. And of course, Jagath Jayasuriya in Latin America, Suresh Saleh in Malaysia, Krishanta De Silva in Bangladesh, and now, of course, you have Chandra Prema serving in Geneva. And there are many others which are too many to mention. A question that we have been raising is General Jagath Jayasuriya, the former army commander, and we have asked the United Kingdom and the Commonwealth, will there be a proper vetting of participants and diplomats to the Commonwealth Games in Birmingham, in the United Kingdom this summer? Because of course, Jagath Jayasuriya, who is responsible for boxing, is one of those people that we need to watch out for. But an important, I think, aspect also of the vetting and screening has, of course, been the kick-in of lay laws, where because of Shivendra Silva being designated under the appropriations regime in the United States, this has tainted the entire unit under his command, with the result that the Sri Lankan army is Leahy vetted as well and is ineligible for US state funding, except of course for humanitarian emergency funding. And so this is something that one also needs to keep an eye on. And in terms of the accountability project, I think it's important to think about how it can support the vetting and screening. And this can be done also to provide another layer of support to civil society organizations who do this kind of work, as well as to bodies at a national level who continue to carry out this function. Like Sanctions, it does send a message to the next generation of officers that there is a cost in terms of their international prestige, because their own governments have failed to deliver on accountability. And one might ask the question, could the catastrophe have been averted in 2009 if there had been a vetting and screening of those implicated in the first JVP uprising? Could that have prevented what happened at Mulivaikal? And I think these are some of the exercises we need to carry out, because you do see this unbroken career path where you finally have someone who is now the president of the country, but who also played a role in the JVP period as well. I'm going to stop there, and I'm going to ask Ambassador Stephen Rapp to speak on new generation mechanisms and what lessons there could be for the accountability project. Thank you, Steve.
Well, thank you, Yasmin. It's a great honor to be with all of you today. And before I talk about the mechanisms, I do have to make a comment about the charm offensive that the government is on now, that Pablo described. Basically, they're asking to be allowed to dispense with truth and justice entirely, to terminate the mechanism that I'll be discussing, to terminate other processes of monitoring and fact-finding. Frankly, processes that were put in effect because of Sri Lanka's failure to abide by commitments made earlier. Seems all motivated by a desire then to reach out to the international community to obtain economic assistance and loans from the financial institutions in order to pay for the consequences of economic decision-making. It's being sold, as I understand it, on the idea that this would be restorative justice, that's what they're looking for, not punitive justice. But frankly, I'm a fan of restorative justice, but restorative justice needs some elements to be restorative justice. One, it needs truth, and that's something they don't want to accept. Two, it requires acceptance of responsibility, and it's all about denial of responsibility. And three, it requires acceptance of the victims. And obviously, if you've met the victims and the survivors in Sri Lanka, you know that this is not what they're looking for. Now, I heard it all when I was in country in 2012, 2014, discussion of sort of no fault reparations, which would probably only, if fully implemented, cover a fraction of economic losses. But what there's a failure to understand is this isn't just about economic losses. This is about the denial of the dignity of the victims to the truth, the denial of their right, their human right, recognized internationally, as Pablo's work was all about, to have their case properly investigated. Basically, they're asking for the continuation of impunity. And as Yasmin just said, this has been the problem in Sri Lanka for 50 years, from the first JVP uprising, certainly the second JVP uprising, where we have incumbents now who are involved in this incredibly bloody suppression that involves so many extrajudicial killings, and that there was never any consequences, never any truth, never any justice. And we saw that with the failure of accountability after 2009. Even during the 2015 to 2019 period, when there was some movement on emblematic cases, they didn't want to confront those white flag killings and surrender killings and the bombardments and the no-fly zones or no-fire zones. There wasn't that effort at all. But then the emblematic cases that involved many times not Tamil victims, like the famous 11 boys that were tortured, murdered, and their parents paid ransoms, but their children were killed anyway. That case, which was investigated, has been entirely dispensed with, and those individuals no longer under prosecution. So what we see is impunity, which is contagious, and certainly the work of the ITJP, the reports that many people don't want to hear because it's so horrendous, to know that there are still young people being picked up, tortured, sexually abused, sometimes then being ransomed as a sort of an act of extortion by their families and arriving in the West. And I've been involved in verifying many of those interviews, talking to people brutally raped, sometimes it's just weeks after those crimes are committed. And that's what we get with impunity. What are we talking about when we talk about mechanisms? We're talking about some way to deal with impunity. And indeed, as has been said by others, the chance of too many cases being pursued universally in third countries is limited. But even a few cases in the sort of dealing with the way that we have a contagion of impunity to some extent, when you do these kinds of cases, it may work. There may be some vaccination effect of it, because you begin to send the message that there are consequences, that there will be no rest in this life, that you won't be able to go somewhere and visit family members or the property that you placed abroad, et cetera, without the risk of being arrested in the future. And that can, I think, begin to turn, we hope, toward a transition in which there is genuine justice back in the home country. We saw that with universal jurisdiction cases in Latin America. Rios Montt, the dictator of Guatemala, pursued for genocide in Spain, eventually prosecuted in his own country. Pinochet for horrible crimes, torture in Chile, arrested in the United Kingdom, though returned, but there to have his amnesty suspended and for investigation to proceed in his home country. That's what we're hoping for. But we have now an entirely new and more expanded approach to universal jurisdiction that is particularly assisted by the mechanisms that were established for Syria and Myanmar. And I've been deeply involved, particularly in the Syria one, but also in the Myanmar one. And it's important to note, however, that these mechanisms are UN bodies. They're not doing a lot of retail investigation on their own, but what they're doing is reaching out to civil society and bringing in the material and vetting and verifying and collating it and using the modern software to analyze it and to find the links, also to engage in some open source investigation or to work with those who are doing it on an external basis. and then building the strong dossiers that national prosecutors need if they're going to pursue a case in Germany. And obviously we've seen in Germany the conviction in Koblenz last month of a Syrian colonel for torture and a life sentence for 27 murders and thousands of acts of torture. A Syrian doctor now on trial in Frankfurt, a Syrian militia man who killed Palestinian refugees in Damascus, alleged to have done that, soon to go on trial in Berlin. And those cases are aided by civil society documentation, but also enormously by these mechanisms. Of course, they can do other things, as we've heard, in terms of providing verified information. Now, I have to be frank, the resolution, the 46-1, did not provide for the fullest kind of mechanism that we have for Syria or for Myanmar. But it is an absolute step in the right direction. And it's necessary that this thing, which has only been there for a few months and is only now beginning to receive a budget and staffing, be able to work with victims, have outreach to victims, discuss with victims and survivors what they're seeking, gather that information, and then find places and to do things maybe that other mechanisms haven't done so much of, tracking the perpetrators and where they happen to be going, tracking assets that may be abroad, where you could begin a prosecution based on the assets and seek recoveries and potentially eventually take a criminal case against an individual if you had jurisdiction. So there are a lot of inventive things that can be done in this area, all I think with the goal of ending impunity in Sri Lanka. But it's an extremely important step. It's working in other places, and it really needs to have an opportunity to work here, because without it, we won't have truth. We won't have justice of any sort in Sri Lanka.
I think that was incredibly helpful. I'm now going to turn to our two representatives from the Office of the High Commissioners for Human Rights, Livia Cosenza and Anna Katuru, to really give us an update on where we are with the accountability project. Livia, are you going to start, or will Anna?
Thanks. I will start. Thanks, Yasmin. And good morning, good afternoon, everyone. Thanks for this opportunity to provide you with a brief update on where the office is with the implementation of the resolution. So the office started implementing the new accountability mandate given by Resolution 46/1 with the startup team undertaking some preparatory work since May last year. And a dedicated webpage for the Sri Lanka Accountability Project has been created that we can share for those who haven't seen it yet. The office has now recruited more staff with a range of specialized expertise for these very technical mandates. We include specialists on international, criminal, and humanitarian law, human rights, sexual and gender-based violence, victims' rights, and information management. And the recruitment for the remaining staff is still ongoing. The team, as mentioned, is based in Geneva, and it is under the authority of the High Commissioner for Human Rights. And I think it's important to clarify that, as also to specify how this project is different from the independent mechanism, for example, on Syria that was established by the General Assembly, or the Myanmar one established by the Human Rights Council. These are fully independent bodies, each headed by its own senior UN official. And these mechanisms are also considerably larger in terms of staffing and resources. This project is also different from independent commissions of inquiry or fact-finding missions that are established by the Council to inquire into a specific situation and then report back directly to the Council, because these mandates are also fully distinct from OECHR. So whatever relevant developments related to the work of this project will not be included in separate reports produced by the team, but it will be included in all the future reports to the Human Rights Council, which the High Commissioner has been mandated to present by the resolution 46/1. And these are an upcoming report that will be presented to the Council on the 3rd of March this year, and then a comprehensive report, including further options for advancing accountability in September 2022. And while it's important to note that while the resolution does not indicate any specific time frame for the implementation of the accountability mandate, the resources given to the office are linked to the resolution, whose reporting time frame, as I said, goes until September 2022. So any possible renewal of the mandate will have to be discussed and decided by the Council through the adoption of a new resolution in September 2022. With regard to the mandate specifically, so the mandate covers all violations and abuses of international law in Sri Lanka by all parties. And the team's work has been focusing on the main elements of the mandate. First of all, the collection, consolidation, preservation, and analysis of information and evidence. So the office has developed an information and evidence repository and has identified already a large number of information items already held by the UN, and the team will further analyze this information from a criminal justice perspective with a view to identifying gaps and priorities to then go for further information collection. And of course, the consent of information providers to further external uses is fundamental in the handling of such information. Second is the development of possible strategies for future accountability processes. As I said, the resolution requests OECHR to include further options in the High Commissioner report in September 2022. And to do that, one of the main elements of the resolution is to advocate for victims and survivors. This means that a victim-centered approach that is central to all of OECHR protection and accountability work is part of this project. And this means that victims and survivors' testimony, evidence, and information are maintained safely and securely, that the OECHR will have to conduct, of course, a risk assessment and assess all the protection concerns, especially in a context like Sri Lanka. But also, and most importantly, the team will work with victims and survivors to facilitate their informed participation in the work of the team, including in the definition of accountability and reparation processes. And fourth, the support, of course, to relevant judicial and other proceedings, including in member states with competent jurisdiction. That's the fourth element of the resolution. And the UN has already well-established internal processes for such cooperation in judicial and non-judicial context. And the Sri Lanka project will fully apply the same policies and standards in this work. Of course, through the reports and other and the webpage, OECHR will keep the government and other stakeholders informed as it takes steps to implement the resolution. And now I'll leave the floor to Anna for a few words. Thanks.
Thank you, Livia. Over to you, Anna.
Thank you, Livia. Thank you, Yasmin. Pleasure to meet you all today. My name is Anna Katuru. I'm the legal advisor on the Sri Lanka Accountability Project. And I think my colleague Livia covered our mandate and our work quite extensively. So I just would like to highlight the fact that the team is still being built, and we all have backgrounds in international human rights law, in international humanitarian law, and international criminal law and criminal justice, and including expertise on women's and children's rights. And so we're a dedicated team that will be working on these issues and has started working on the extensive working on, or has based our work on the extensive body of information that is already there. And we have yet not made any call for contributions or have specifically called on groups to provide information. But we do have an email address where you can contact us if you have questions or if you wish to share. And the email address is slaccountability@un.org. I will see if I can put it in the chat, and otherwise I will share it with the organizers. Thank you very much.
Thank you, Anna. I think that we'll ask the organizers to post that email address up. Can I turn to you, Tissa, to respond? I think we've had quite a mouthful of information, but it's really interesting to hear from Sri Lankans themselves around how they see all of these issues and how they see these bodies functioning. Thank you.
Hello, and thank you for inviting me to speak on this panel. My task today is to offer a Sri Lankan perspective on the tools of accountability and justice described by the speakers before me. In the past, I have said that the international community could do more for accountability than it was then doing, and the tools put forward today are certainly encouraging. But I feel that, if the international community were to limit its actions to these, progress would be slow, haphazard, and inconsistent. The proposal to create an investigative mechanism on Sri Lanka under UNHRC Resolution 46/1 disappointed Tamils by and large. Their hope that the UNHRC would use all available tools to refer Sri Lanka to the International Criminal Court or appoint a special rapporteur for the country failed. Resolution 46/1 strengthens the Office of the UN High Commissioner for Human Rights to collect, consolidate, analyze, and preserve information that could be used to pursue legal action against perpetrators. While the challenges to this body's independence has been referred to by earlier speakers, I am glad that, as Livia was saying, an important issue, whether victims and survivors will have meaningful access to their records, or whether it would be simply be a repository for information that would be used in the distant future, was partly answered. The other measures addressed, such as economic sanctions, travel bans, universal jurisdiction, vetting of military personnel, are all laudable. But I am not sure whether they will yield results consistently to make it effective. Why do I say this? The main reason is that how Western governments, which spearhead moves to punish individual military and political leaders, view Sri Lanka's geopolitics. They mostly view the country as moving inexorably into Beijing's orbit economically and militarily. Therefore, bureaucrats in Western foreign policy establishments like the US State Department warn those lobbying for more stringent measures on human rights violations that doing so would drive Sri Lanka closer to China. This is one of the reasons given for promoting military-to-military relations between the US and Sri Lanka, and not looking for lasting accountability or justice. The importance of this perception of military establishments helping each other can be seen from a couple of examples. The US State Department imposed a travel ban and asset freeze on Sri Lanka's Army Commander General Shavindra Silva and his family, as has been referred to by earlier speakers. However, the US continues to train Sri Lanka's army under Shavindra Silva. It also upped its support for the Navy. And when the trend of militarizing civilian institutions saw Shavindra Silva being made head of the body fighting COVID-19, media reports appeared highlighting the then US ambassador handing over aid for COVID relief. Therefore, there was no consistent message of sanction. It was just that Silva cannot travel to the US. When there is public perception that US officers of state do not adhere to the spirit of sanction, but work with war criminals, it sends a message that the US is not serious about justice or accountability. Also, travel bans and asset freezes are to be effective. US sanctions need to include more persons accused of war crimes, such as Defense Secretary Kamal Gunaratne and retired Admiral Vasantha Karanaka. Next is the matter of countries using universal jurisdiction to take legal action against perpetrators of atrocity crimes present on their soil. Although moves were made to arrest them, at least 4 senior Sri Lankan officers, and this has been referred to by other speakers as well, Jagat Jayasuriya, Tagi Galage, Jagat Jayas, and Prasanna Silva, eluded arrest because they were protected by the diplomatic and security establishments in the countries where the presence was challenged. Therefore, hoping the universal jurisdiction will facilitate Sri Lanka's war criminals to be arrested on foreign soil is useful, but unfortunately an unreliable mechanism for justice and accountability. This brings us back to the importance of the international community working with Sri Lankan people directly to make perpetrators accountable. Among the goals of today's roundtable is strengthening civil society in the quest of justice. And this should not only be NGOs, but movements based in the north and east of Sri Lanka. And I mean specifically, families of the disappeared are movements spearheaded by women seeking justice for the disappeared to direct action such as protests and lobbying. They have been portrayed in the media as weak women who can only weep and wail for their disappeared loved ones. But this image ignores the truth. They are women with incredible agency, courage, and understanding of the policy landscape who have defied police and military brutality, intimidation, and surveillance to take their fight to the Presidential Secretariat in Colombo and the chambers in the Palace of Nations in Geneva. But what has the international community done to support them? For instance, the mothers of the disappeared have consistently rejected 2 institutions, the Office of Missing Persons and the Office of Reparations, established under the Transitional Justice Mechanism as a sham devised by Colombo to embellish its international image. It is a sham because legislation states that the OMP findings cannot give rise to criminal and civil liability. Yet the international community continues to support them. High Commissioner Bachelet is supportive of it in her reports, while the US, UK, and EU fund it. By this, the international community gives legitimacy to an institution that the survivors reject. Let me conclude by saying that I am supportive of the measures the earlier speakers have discussed as instruments of bringing about justice and accountability. But by themselves, they are inadequate. Therefore, while the international community advocates strongly for these and for a referral to the ICC, it should also support and strengthen movements in Sri Lanka's northeast, such as those searching for the disappeared, fighting for the release of political prisoners, and for reclaiming land forcibly taken over by government agencies. Thank you, and I look forward to taking your questions.
Thank you, Tissa. And I think you've raised a number of the issues that many Tamil victims and organizations have raised. And it's interesting in your last comments, all of these were issues that emerged from the OISL inquiries, recommendations under Resolution 30/1, commitments really. And so it's interesting looking at how those will be taken up. I have a number of fabulous questions in the Q&A, but before I take them, I see a note from Anandi Haka, who's an MP in Sri Lanka, and I just wonder if we can give her an opportunity to raise her question. Anandi Haka, do you want to go ahead? Francis, are we able to assist Anandi to put her question?
I am not sure. I think she has to be upgraded to a panelist and then ask it. So maybe if you start with one of the Q&A questions first, we'll try and sort out the technical element.
Okay, thank you. So I think that there are a number of interesting questions, but perhaps I'm going to start with the one that came from Alan Keenan, where Alan has, I think, talked about the fact that everybody made excellent presentations, But he does make a point that one of the biggest challenges so far has been the question of the lack of political will. And I think that that goes directly to the question that Tissa raised, that while all of these different measures are to be lauded, at the end of the day, what many victims seek is some kind of direct process for accountability. And I do think that what we're beginning to see in the Human Rights Council is an incredible polarization globally. And that really affects the ability of the council to act to support the rights of victims. So I'm going to throw that question particularly to Pablo and Steve and anybody else who would like to answer that, because I think this is affecting the real question of criminal accountability, which if we want to deal with mass atrocity crimes, I think is an absolutely critical issue. So let me start with you, Pablo, on that question.
Thank you, Yasmin, and thanks to Alan. Alan may have realized that in my comments, I said that UN headquarters at different times during the Sri Lankan crisis was surprisingly silent, and that is difficult to understand. So I mentioned this because I am with you in thinking that there is a great deal of leverage that the international community should be trying to take advantage of that it rarely does, as a matter of fact. And I think that Sri Lanka has learned all the wrong lessons about a sort of clever geopolitical triangulation in order to exempt itself from commitments that we call international in the sense that they are embodied in international documents, but that in the end are always commitments to a country's own citizens. Sri Lanka, I think, is peculiar in this respect because its history is one in which there are victims in all groups through the different waves of violence that the country has experienced. And therefore, it is particularly difficult to understand why it is so difficult for the majority not to see, in a context in which there has been not just inter, but intra-ethnic violence, that accountability and coming to grips with the past is a necessary condition for breaking cycles of violence. Be that as it may, the fact that internally this is a message that people are not adopting, I do think that there is a very, very important role for the international community in trying to exercise more leverage on Sri Lanka, and that this can be done without a great expense to any of the great powers. They just need also, if you talk about political will, it is missing not just in Colombo, it is missing everywhere else, in London, in DC, in Beijing, and I must repeat, at UN headquarters as well.
Thank you, Pablo. Steve?
Well, let me jump in and note that, you know, governments aren't monolithic. Countries, many great powers, not all of them are democratic, and their governments reflect what the people demand. I certainly know that I became ambassador in September of 2009. The U.S. hadn't done enough during the closing days of the war in 2000, 3 months before I arrived. But our Congress had passed a resolution calling for a report on the crimes that may have been committed during that final phase, which felled my office. And over time, we built a coalition within the U.S. government with strong support with our Congress to really put tough conditions on Sri Lanka when they made promises of accountability and failed to fulfill them. That led, of course, to 3 resolutions in the Human Rights Council, culminating in the OISL one, which of course then led on after the report and the somewhat opening that we had in 2015 toward the resolution that provided the transitional justice mechanisms. The point is that it took effort within these countries, and right now, for instance, one of the issues is will Sri Lanka, without complying with its international obligations, would they get a loan from the IMF? Frankly, I know in my country, we always vote for those loans unless Congress has passed a rider saying don't. And so lobby Congress, put it in the appropriations bill, which they're going to have to pass after they finally finish with the continuing resolution series, saying we vote no unless they do 1, 2, 3. And there's a bipartisan coalition, at least in the Senate Appropriations Committee, that I think would support that kind of thing. So, and the same kind of pressure needs to be brought on the UK government. We do recall how certainly during the Cameron period, when they had the Chogam and the Queen didn't come and he went to the north, that there was pressure finally brought from the United Kingdom, and they certainly played a positive role in Geneva in their leadership of the contact group. So it takes this kind of pressure everywhere, and certainly there are going to be military people and others saying, oh, we want ship visits, we want to do this, we want to do that. You say, wait, we can't do it because, and we have things like Leahy vetting in the US that keep these people with human rights records, bad records, and the units from coming to training. I heard complaints from the military when I visited up north in 2012. Saw one of the generals who was complaining he couldn't go to a training in Hawaii. I mean, the point is that these things came legislatively. So it takes pressure, and the diaspora and others and the whole human rights community. And Sri Lanka is so important to almost everything else because it's a place where we worked through the process. We've had the findings. We've had all of these efforts and commitments. And now if we're going to throw it all out, then nothing that's being done on Ethiopia or Belarus or Venezuela or Syria or any Myanmar, North Korea, any of these other situations matters very much. And so I think the whole issue is at stake at this point, and that's why I think like-minded people around the world and those that are allied in government really need to be tough on it. And of course, certainly not just in the global north, but in other countries around the world. And so I think it's an important battle. It's encouraging to me that even at this stage, we were able to get the resolution 46-1, as weak as it was, and as hard as the government was working against it. And we're just going to have to continue to press to keep this mechanism going, to build it up, to provide it with the resources, to make the demands on it to be effective, in the hope that we'll have. I mean, I thought we had in 2015 a recognition in country when they voted as they did then, that it wasn't good to be completely in isolation from Western countries with whom they had their natural affinity, and that taking money from China to build a port in the southeast and at high interest and an enormous cost was not a good thing for the country. So I do think that that if we handle this right and continue to work with the victims and with people around the world, I think we can continue to press this cause forward. And we've had setbacks before, but we're going to continue to push it as effectively as possible, but always in alliance with and with support of. And if we don't have that support, we're doing the wrong thing. But I continue to hear the support from the victims and communities that do whatever we can. They'd like to see more, but I think what we've been done in this last resolution really is important and needs to be built upon.
Thank you, Steve. I'm going to take Priya because she's got a hand up, and then I'll go to Anandi. Priya, over to you.
Just to build on that point in terms of needing to do something now, to add that, we had the UN Petri report. We also had the UN Panel of Experts report, Yasmin, that you were involved in. We had the LLRC, and we also had various domestic investigations in Sri Lanka, all of which have brought us to this point. So just to note that in this history of lack of action, lack of accountability, as Ambassador Rapp says, it's really critical that this mechanism that follows in a spate of efforts over many, many years provides another bite at the cherry, so to speak, despite the limitations that other panelists have identified.
Thank you, Priya. I'm going Nandihaka, if you could put your question, you need to unmute.
அனைவருக்கும் வணக்கம். இந்த நிலைமாறு கால நீதி என்றதுதான் கடந்த காலத்துல பேசப்பட்ட விடயம். ஆனால் நிலை மாறாமல் தான் நாங்கள் இருக்கிறோம். அடக்கப்பட்டவர்கள் அடங்கி போயிருக்கிறதும் எங்களை அடக்கியவர்கள் எங்களை ஆளுறதுமான ஒரு நிலைதான் எங்கள்கிட்ட இருக்கு. ஆனா நாங்கள் நிலைமாறு கால நீதியை நாங்கள் பேசிக்கொண்டு இருக்கிறோம். ஆனால் இன்றைக்கு இந்த யுத்தம் இன்றைக்கு 2006ஆம் ஆண்டிலிருந்து ஐக்கிய நாடுகள் சபையில 9 தீர்மானங்கள் இலங்கைக்கு எதிராக இலங்கைக்கு கொண்டு வரப்பட்ட தீர்மானங்கள். அது இன்றைக்கு 15 வருடங்கள் ஒரு சின்ன நாடு இலங்கை ஐநாவை ஏமாத்தி கொண்டே வந்திருக்குது. ஆனால் இன்றைக்கும் மனித உரிமை மீறல் நடந்து கொண்டுதான் இருக்கு. ஏனென்றால் சில விஷயங்கள் வெளிக்கு வரும், பல விஷயங்கள் வெளிக்கு வார இல்லை. ஏனென்றால் அவ்வளவு அச்சுறுத்தல்ல தான் இந்த மண்ணில சாட்சிகள் வாழ்ந்து கொண்டு இருக்கிறோம். இன்றைக்கு ஏர்போர்ட்ல வந்து இறங்கின உடனேயே கைது செய்யப்பட்டு 1 வருஷம் கணக்காக எந்த ஒரு பதிவுகளும் இல்லாமல் 4ஆம் மாடியில கொண்டே வச்சிருக்கிற நிலைமையும், அந்த உறவினர்களை பார்க்க போற கணவனை பார்க்க போற அல்லது தமையனை பார்க்க போற பிள்ளைகள்ட்ட பாலியல் லஞ்சம் கேட்கிற அல்லது பாலியல் ரீதியாக துன்புறுத்துற நிலைமை இன்றைக்கும் இருக்கு. இது போர்க்காலத்துல மட்டுமில்ல, இன்றைக்கும் அந்த துன்புறுத்தல் இருக்குது. அதே போல வீடுகள்ல போய் இராணுவ புலனாய்வு, இராணுவம் விசாரிக்கிறதுல இருந்து எல்லாம் நடந்து ஊடகங்கள்ல எல்லாம் தணிக்கை செய்யப்பட்டு இருக்கு. அப்ப சாட்சிகளை விசாரிக்க வேணும் என்றால் உண்மையில இந்த மண்ணில இந்த இடத்துல சாட்சிகளுக்கான பாதுகாப்ப நிலையை ஏற்படுத்தித்தான் சாட்சிகள்கிட்ட நாங்கள் விசாரணையை செய்யணும். நீங்களும் அதுக்கான ஒரு களத்தை இங்க உருவாக்க வேணும். இலங்கை அரசாங்கம் சும்மா வீம்பா சொல்லிக்கொண்டே இருக்குது, இங்கே ஒன்றும் நடக்க இல்லைன்னு இன்றைக்கும் ஊடகவியலாளர் உட்பட எல்லாரும் அச்சுறுத்தப்பட்டு கொண்டுதான் இருக்கிறேன். மற்றது உள்நாட்டு பொறிமுறையாண்டு கொண்டு வந்து நீதித்துறை, இலங்கையில இருக்கிற நீதித்துறை வந்து சர்வதேச நியமத்துக்கு உட்பட்டதாக இல்லை. அதுல நிறைய குறைபாடு இருக்கு. இன்றைக்கு கிருஷ்ணாந்தி படுகொலையில சம்பந்தப்பட்டவர்ல இருந்து இன்றைக்கு எல்லாரும் அரசாங்கத்தால விடுவிக்கப்பட்டு இருக்கிறாங்க. அரசு ஆறார் ஆட்சிக்கு வரணுமோ அவ தங்களுக்கு விருப்பமான ஆட்கள் எல்லாரையுமே அந்த குற்றத்தில இருந்து விடுவிக்கிற தன்மையை நாங்கள் நெடுகளுமே பார்த்து கொண்டுதான் இருக்கிறோம். தங்களுக்கு எதிரான ஜனநாயக குரலை எழுப்புற ஆக்களை வந்து அவைய வந்து நெருக்கிறது அல்லது அவைக்கு எதிராக நீதி சட்டம் என்று பார்க்கிறது எல்லாத்தையும் நாங்கள் பார்க்கிறோம். உண்மையில எங்களுக்கு தேவை இன்றைக்கு யுத்தம் 2009 முடிஞ்சதுக்கு பிறகு இன்று வரை நாங்கள் ஒரு விக்டிமா இந்த ஒரு நீதி வேணும், அதாவது பொறுப்பு கூறலை செய்ய வேணும், அரசாங்கம் நிகழாமை ஒன்றை செய்ய வேணும் என்ற பக்கம் எல்லாம் பார்க்கிறோம். அதுபடியால்
இவ்வளத்தையும் மொழிபெயர்க்க விட்டீங்களா உதவியா இருக்கும். In the recent past, we had been repeatedly talking about transitional justice. However, there has been no transition in Sri Lanka. We had been facing the exact same situation, that the Tamils are being suppressed and the ruling race is occupying and they are committing all the crimes repeatedly. So there had been no transition in reality, but we had been repeatedly talking about transitional justice. And in particular, the ongoing violations are still occurring. There had been almost 15 resolutions passed in the UN so far, Sri Lanka is a small country compared to the other countries in the world, but it is successfully deceiving the UN, and there had been no resolution, no improvement so far. For example, a person who arrived at the airport was arrested on arrival, and it's more than a year. There had been no news about that person's detention, and it was not even reported anywhere. Likewise, there had been many ongoing violations. Even a number of family members who goes to visit their family members in detention are being asked sexual favors in return of being allowed to see their family members or speak to them. So these kind of violations are still ongoing.
Thank you, Geet. I'm going to take a few questions and then throw that back to our audience, including
I think, Yasmin, I think Anandi hadn't quite finished.
Oh, okay. But
நல்லது உண்மையில நாங்கள் என்ன எதிர்பார்க்கிறோம் என்றால் ITJP இந்த ஒரு பெரிய ஒரு பணி எங்களுக்கு ஒரு நம்பிக்கையை ஏற்படுத்தி இருக்குது. உண்மையில ITJP செய்கிற ஒரு நீதியை பெற்றுத்தர வேணும் என்றதுல எடுக்கிற நிறைய நடவடிக்கைகள் பாதிக்கப்பட்ட விக்டிம் என்ன போன்றவர்களுக்கு ஒரு நம்பிக்கையை ஏற்படுத்தி தந்திருக்கு. ஆனால் என்னத்தை எதிர்பார்க்கிறோம் என்றால் நிறைய காணாம போன அம்மாமார் அந்த ஏக்கத்திலையும் கவலையிலையும் நோய் காரணமாக இறந்திருக்கணும். அப்ப விக்டிம்ஸ் எல்லாம் செத்துக்கொண்டே போயினம். ஆனபடியால் மிக விரைவாக இந்த மண்ணில இலங்கை அரசாங்கத்துக்கு உண்மையில நான் நினைச்சேன் இந்த பொருளாதார நெருக்கடியை சந்திச்ச பொழுது இன்றைக்கு இந்தியா எத்தனையோ பில்லியன் காசை கொடுக்காம விட்டு இருந்தால் சில நேரம் ஐநாவின் சில நடவடிக்கைகளுக்கு ஒத்துழைப்பு கொடுக்க வேண்டிய நிலைமை அரசாங்கத்துக்கு ஏற்பட்டிருக்கும். ஆனால் அமெரிக்காவின் செல்ல பிள்ளையும் இந்தியாவின் நல்ல உறவையும் பேணுகின்ற மிலிந்த மொரகொட மாதிரியான ஆக்கள் வெளியுறவு அமைச்சராக இருக்கிற பீரிஸ் போன்றவர்களுடைய செயற்பாடும் இன்றைக்கும் தொடர்ந்தும் சர்வதேசத்தின் ஆதரவை இலங்கை பெற்றுக்கொண்டு இருக்கிறதுக்கும் மற்றது இணைய அனுசரணை வழங்குறேன் இன்னதை செய்வேன் என்று ஒப்புக்கொண்ட அரசாங்கம் பிறகு நான் அதுல இருந்து விலகுறேன் என்று எல்லாம் மீம்பு பேசி இன்றைக்கு நாங்கள் நம்பிக்கை இழந்து ஒரு சோர்வோட வாழுற ஒரு கட்டத்துல கொண்டாந்திருக்கு. இப்ப நான் உங்களுக்கு கேட்கிறது நாங்கள் அடுத்த கட்டம் என்ன நடவடிக்கையை எடுக்க வேணும். உண்மையில விக்டிம்ஸ் எப்படி பாதுகாத்து தங்களுடைய சாட்சியங்களை கொண்டு வர வேணும். மற்றது தொடர்ந்து இன்றைக்கும் 300க்கும் மேற்பட்ட அரசியல் கைதிகள் இப்ப வந்திருக்கணும். எப்படி என்று சொன்னால் விடுதலை புலிகள் பாட்டை போன்ல வச்சிருந்தது, தேசிய தலைவர் பிரபாகரன் படத்தை போன்ல வச்சிருந்தது, அல்லது விடுதலை புலிகளுக்கு ஆதரவாக முகப்புத்தகத்துல போட்டதென்ற வகையில 300க்கும் மேற்பட்ட இளைஞர்கள் போர் நடக்க அதில் குழந்தை படியங்கள் இன்றைக்கும் சிறையில இருக்கிற நிலைமையை நாங்கள் பார்க்கிறோம். இதை விட அரசியல் கைதிகள் தொடர்ந்து இருக்கிறோம். நாங்கள் கையால கொண்டே சரணடைய கொடுத்தவைக்கு இன்றைக்கு 12 வருஷம் கடந்தும் நாங்கள் இதையும் அடைய முடியாம மிக மனச்சோர்வோடு இருக்கிறோம். நாங்கள் அடுத்த கட்டம் என்ன நடவடிக்கைக்கு போகலாம் என்றதை தெளிவா பேசினீங்கள் என்றால் நன்றா இருக்கு. நன்றி.
We are very grateful for the ITJP for taking forward these kind of attempts, endeavors to seek justice for the Tamils, including victims, including myself, who ourselves handed our family members to the Sri Lankan authorities and still waiting to know what happened to them. There are a lot of mothers of the disappeared who are passing away, and the worry we have is the victims are dying. So we really need a solution at the earliest. And for example, there are the political reasons. If the India refused to grant the loan to Sri Lanka, there could have been some changes possibly. And also Milinda Moragoda, who is a pet of the America, USA and India, they had been working against these proceedings, and therefore my question is, there had been almost 300 at least 300 former LTT members and youth who had been arrested for having LTT members' photographs and national leaders' photographs on their mobile phones. So these are just few examples, and the serious concern is that the victims and the witnesses are dying and the time is passing. So I would like to know, the question is, what the necessary step, what step we need to take? That's what we would like to know from you.
Thank you, Geet. I'm going to take Mr. Ravi next, and then I'll throw in a few more questions that have come through the Q&A, and I'm going to give panel members a last moment to respond to any one of them. Mr. Ravi?
Thank you, Yasmin, and thank you, everyone. Even though Sri Lanka tried to stop evidence collection mechanism and many other texts in the 46/1, it has been passed successfully, but somehow Sri Lanka and its allies managed to use the process and procedures of UN to drag, and we lost almost 9 months after the resolution, and the budgetary conditions are not very favorable, so that the staffing is not enough to continue the process successfully. My question is, unlike all other resolutions on Sri Lanka are restricted within the LLRC period, this resolution doesn't restrict the time to collect the crimes committed. So even though, as Livia said, even though they already have over 120,000 evidences to be processed, I'm afraid whether that can describe the nature of the crimes in the past from 1948 onwards, particularly those crimes committed using the Application of Prevention of Terrorism Act since 1979. So we need some kind of process that should allow the collection of new evidence. As Anandi said, there are many victims, not just those victims, the mothers or the evidences who are dying or who are in the losing their memories. These people going beyond 2008 and 9, that is all the way up to 83, 77, and even before, have to be given an opportunity to provide their evidences. Thank you very much.
Thank you. So, there were a number of questions that were posed on the chat. And Amanda, particularly, I think for you, the overlap between the application of universal jurisdiction and travel ban sanctions. And I think it picks up on the contradiction that you raise, that we want to lure alleged war criminals into territory where they may be arrested and prosecuted, but on the other hand, travel bans ensure that they never reach these jurisdictions. And do you have any suggestions to make regarding the enforcement of war crimes legislation under universal jurisdiction more effective? There was also a question posed by Elias: should states develop undisclosed sanctions lists so that the listed can then be subjected to universal jurisdiction? There were also a number of questions around access to the material that the accountability program will gather. Also, what will be the rules in terms of engagement, and what kind of access will there be for a range of third parties, including member states? Another question, dealt with the question of international protection for witnesses who have fled the country. And of course, the big question is really criminal accountability, and that's the thread that really runs through the Q&A process. So I'm going to, because we have, I think, exceeded our time already, but I'm going to allow everybody a 2-minute opportunity to respond to anything that came across today, which you're planning to deal with. Tissa, let me start with you.
Well, thanks. Well, a couple of things. Most importantly, I think Stephen referred to this, about how there was this idea that the Wickremesinghe Sirisena government in 2015 would appear to have been more responsive to, dealing with war crimes and issues like that. Whereas actually they failed to do that because of various reasons. I think it's very important to note that Sri Lanka's problems in dealing with war crimes and atrocity crimes is structural. It has nothing to do, or it has very little to do with the regime in place. That is because the institutions that the state and the institutions associated with it are run by the Sinhala Buddhist elite. And they have been consistently, whichever government was in power, they have been consistently against non-Sinhala Buddhist groups, whether they be Tamils and now Muslims and Christians also, gaining power to be equal citizens. And that is one of the reasons why they have consistently seen to it that even war crimes and issues associated with it, because Sinhala soldiers, the Sinhala Buddhist soldiers, are seen as heroes. They fulfill the aspirations of the Sinhala Buddhists, or that is how the Sinhala Buddhist nationalists who control the levers of state view them. And therefore, even in the future, I think, even if the Rajapaksa regime is replaced by another, we should be very, very careful that we don't see them as being more liberal and more democratic. They might be in certain areas, but the fact that they were not, that although they were not in the area of accountability and justice for the Tamils, but were seen as such, was one of the main mistakes that the international community did as far as the Tamils, as far as accountability and justice went between 2015 and 2019. The other issue, the second issue, is about what Anandi referred to. These issues are continuing. Women are being raped, they are being sexually harassed, torture is going on, so on and so forth. And I think one of the main reasons for that is because we look at some of these issues from an external point of view. We do not work with movements in the North and East, which I alluded to, like the mothers that disappeared, like those fighting for political prisoners. Anandi said over 300 people are under PTA right now. So I think greater cooperation from the international community with movements working in the North and East would help ease some of these, because those women and men are people with a lot of agency and people who are willing to risk a lot to see that justice and accountability are brought about, because they are the victims, they are the survivors, and they understand all about it. So therefore, I think it's very important that in the future, we work with movements like that, rather than perhaps ignore them. Thanks.
Thank you, Tissa, for that. And I think two important messages: that it's not about regime change, but it's really looking also at the structural impunity that exists. And then, of course, working with local structures, I think, is important. I'm going to turn to Amanda because I'm deeply conscious of the fact that you have a time constraint and you're chairing a meeting, I think, in the next 10 minutes or so. So let me go to you.
Thank you very much. I noticed that there were a few questions about sanctions, so I thought I would just briefly touch upon about 3 of them. So first, to Elias's question, I think one difference to keep in mind between the sanctions regime and universal jurisdiction is the evidentiary threshold and the burden of proof that I mentioned earlier. So a universal jurisdiction prosecution is a criminal proceeding, which means the charges must be proved beyond a reasonable doubt, whereas the sanctions regime, at least in Canada, uses a reasonable basis to believe standard, and these have significant legal differences. So I don't think it's a good idea to merge sanctions lists and universal jurisdiction, especially in an undisclosed manner, because this actually further reduces transparency and weakens due process rather than strengthens it. Now, to Lorenzo's question about strengthening war crimes legislation, in my opinion, governments who have universal jurisdiction laws need to provide the adequate resources to their war crimes units so that these units within the Department of Justice actually proceed with full investigations and prosecutions, rather than what they're doing right now, which is using there's an over-reliance on immigration remedies such as inadmissibility and deportation. So governments should strengthen their war crimes unit to actually investigate and prosecute. And they should also ensure that political and diplomatic relations don't get in the way of universal jurisdiction investigations and prosecutions. In many countries, a UJ prosecution needs to be approved by the Attorney General, which means that the political sphere can exert some degree of influence on which cases actually get prosecuted. So I think with greater resources and more transparency and independence, prosecutors will be better equipped to enforce war crimes legislations. And finally, I noticed a question from Roy, and I just briefly wanted to touch upon this, which is about broad economic sanctions on Sri Lanka. The only thing I'd like to mention is that we need to distinguish between broad economic sanctions and targeted human rights sanctions. And as we've learned and as we've seen in other contexts, and I'll bring up Iraq as an example, but also Iran currently, countries who have endured broad economic sanctions, we've seen that it tends to impact the innocent civilian populations much more than the state and the structural issues that are going on that we just discussed. And so I actually find that these broad economic sanctions can undermine a lot of the human rights principles that we would like to uphold. So I'd like to just make I just would like to point out that there is a difference between targeted human rights sanctions against individual perpetrators who have played a role in gross human rights violations versus a much broader sanctions regime. Thank you.
Thank you, Amanda, for that. Thank you for participating in this. Let me turn to you, Priya.
I'll sum up with a few points. The first one raised by Anandiaka is such a significant one, which is the issue of ongoing violations. And she mentioned a variety of violations, those relating to the arbitrary detention of political prisoners or alleged arbitrary detention of political prisoners, and also the ongoing sexual violence linked to women who are perhaps visiting or searching for family members. So this is an important point to note, bearing in mind that the OISL report concluded in 2015, and therefore there has been a gap in some ways in terms of the information gathering process between that time and the mechanism and the resolution that set it up last year. So that's a gap that can be noted in terms of the processes that need to be undertaken to fill that gap. Livia mentioned that attempts later down the line would relate to, or investigations would relate to filling gaps and prioritization. So that is an area to note, I think. Firstly, ongoing violations, the temporal gap is the second point. And to end on a positive note, as was mentioned, there has been efforts made to recruit specific expertise relating to sexual and gender-based violence, which is critical. And I note this because in relation to this type of crime, one of the issues we have faced in terms of international accountability is that accountability for it tends to be tacked on in the end. It's not prioritized in the initial stages of an investigative or accountability process. And having this set up upfront in terms of expertise is a step is a positive step in the direction of accountability for sexual and gender-based crimes in this conflict. I'll leave it at that.
Thank you, Priya. And I think that they really are important messages, because in a way, having this enhanced capacity in the Office of the High Commissioner, where there are really two streams. The one is the question of the ongoing violations, and the other is this question of the collection and preservation of evidence, but really going back over time. And I think working out how the resources are going to be managed is going to be quite critical. And I'm glad, I think, that there is a specialized expertise. So it's going to be interesting managing that process. Let me come to you, Pablo, because I think that, the one thing that people spoke about is how there hasn't really been a transition in Sri Lanka. And I think that this is a topic that we have often discussed, and which, how do you deal with this question of justice really in a post-conflict period when there've really been different regime changes, but not really transition? So I think quite a critical question. Over to you.
Thank you, Yasmin. And let me start by expressing my agreement with Tisan's 2 points, including the very important point about the structural dimension of the lack of progress, which obviously relates to the question that you pose. But I said before that I find this a bit puzzling because this is not a case, the typical case of, for example, interethnic groups going at each other and then trying to make up. Sri Lanka also includes the 2 JVP insurrections where intra-ethnic incidents as well, and therefore the structural dimension of this, the Sinhala majority being willing to come to grips with its own past and accepting what Stephen insisted on, that acknowledgement is a very important part of justice and accountability. It is a bit hard to understand. There are, of course, plenty of examples of countries that have over time managed to do what Sri Lanka so far has not managed to do. And this has been brought up both in an earlier intervention by one of the Sri Lankan speakers and in the question and answer box. I don't think that there has been a full transitional justice policy ever attempted in Sri Lanka. There have been pretenses of parts of a transitional justice policy being implemented. So Sri Lanka has had more commissions of inquiry than virtually all of the other transitional countries put together. But of course, none of them has been serious. Were the government serious about implementing a transitional justice policy? It would, for example, have taken seriously the recommendations of the task force report to speak about a local initiative, let alone all the international reports that have been written about Sri Lanka. So part of it, I agree with Tisan, has to do with the elite's reluctance to see, in fact, what is in their enlightened self-interest in the long run. Because as a matter of fact, it's not just that they are foregoing the advantages of peace and reconciliation, of which there are many. They are increasing the risk of intra-ethnic, not just inter-ethnic violence, something that the country has already experienced not once, but twice in the past. And obviously there's much more to be said, but I'll stop here.
Thank you, Pablo. I think that you've really nailed some of the problems there. And I think they're going to be very useful questions to consider, both for the accountability program, but also I think for civil society, how to get beyond this question of the ethnic dimension in a country where, the government's own stated policy is one of an ethnic, Sinhala Buddhist majority, and where everybody else is lesser. And so I think these questions of discrimination, which are then also underpinned by the kind of violations that have taken place, are really critical. And it makes me think of, something Manfred Novak said, that, when you go back to how many special rapporteurs have reported on what has happened in Sri Lanka, it's extraordinary that you consider the question of denial and the ability, of course, to manipulate the international community at many, many levels. But I think we have to have hope. And so Stephen, I think that in many ways you have been the inventor of so many new processes which have allowed us to give so many countries hope in a time of absolute impasse around accountability. And so I'm going to come to you then for a comment as well.
Well, thank you. I hope, yes, but you know, delivering the goods is another thing, and very challenging given the limited resources that have been particularly provided to this one. I want to respond first to Anathy, because I remember meeting her 10 years ago and in country, and talking with her about her own experience, and then when she was elected to the Northern Provincial Council. It would be a great thing to have an ability to take the statements, to record the accounts of victims and survivors, all of them, and to have them and to protect those and to find ways to use that information in a justice process. Understand, however, that I mean, those mechanisms that were established that have maybe 12 times the resources that this one does, they're not doing that. They're relying on civil society organizations to obtain that information, and they're to some extent assisting them in making sure it's done in a professional way. Now, maybe not enough of that in terms of standard setting, but that's what really needs to be done here. Now, of course, we've got horrible problems in terms of witness protection and risk management. I know from talking to the victims of forced disappearance and torture and murder and attempted murder and then eventual ransoming, that people that were just conducting surveys about the losses within families, within neighborhoods, doing that in the North relatively recently, had been among those that have been picked up by white vans. So it's not an easy thing to do, but fundamentally, that process of recording, we have to find a way, and ITJP does it obviously with people that are possible to that have come off into the West, that we do it, but that's what's needed in that regard. But understand what mechanisms are fundamentally about and how they've conducted themselves to date is they're dealing with the responsibility for this crime. It's important, of course, to know all of the crimes that are committed, but then to link that to individuals who could be sanctioned, who could be prosecuted. And of course, those individuals are within structures of the state and within the military and the security services. And so if you talk to the head of the Syria mechanism, she'll talk about the structural investigations that they conducted, and they build that structure and that information so that we can put different people within that structure in terms of their criminal responsibility or for whatever other purposes, even the vetting that Yasmin talks about. So that's an extremely important part of what needs to be done. And then there's the question of dealing with individuals who may be traveling and elsewhere that the governments are interested in. They respond to those requests and then build information to fit those individuals within that structure and to provide those authorities with that information. So that's the kind of thing that we're talking about being done here, but all being done with a very hostile government, with people under great risk when they communicate. And that means that they've got to develop sophisticated and careful means to deal with that communication and outreach, and fundamentally recognize that, of course, their mandate is to fulfill the interests of justice of those victims and survivors. But they do that by building out an investigation to potentially be able to hold people responsible. And when those cases are available, they need to be strong cases. I mean, Canada's done 2, they lost 1, they won 1, you know, the UK has had 2, they've lost 1, they won 1 in terms of systems. So it's important that these cases be built very strongly and to have that kind of evidence in those files. So that's what we're looking for here. I appreciate our Geneva friends being on because they know how challenging this will be to do with the resources, but I think we've got the foot in the door here, and we've got to press to continue to build these resources to do that. And then we can begin to have some cases brought in countries, just as we've seen in the difficult case of Syria, where you've got a very awful regime with Russian support, and people are being convicted, and high-level individuals are under international arrest warrants. So it's possible to do, and it needs to be done here.
Thank you, Steve. I think that was very inspirational. And I think you raise an important point that even though the accountability program has limited resources, we have to find a way of making sure, now that we've got a foot in the door, to ensure that it is able to be effective. Livia and Anna, I know that you have responded to some of the questions that have been raised in the chat, but perhaps a last opportunity if you want to make a final comment.
Thanks, Yasmin. Yes, we addressed some of the questions, and maybe just a few points to reiterate and to answer some of the others. Just to, I think it's very important to remember that this mandate is not limited to violations and abuses by a particular party to the conflict or to particular victims, or like specific to a particular period in time and any geographical area of Sri Lanka. So this gives like broader opportunities to explore, to implement the mandate. Second, that the mandate, I mean, one of the main elements of the mandate is to collect, consolidate, preserve, and analyze information. So the collection part is in the mandate, and maybe just to make it a bit clearer for maybe, we had already the OECHR investigation on Sri Lanka, and that, as you said, there was the panel of experts, but let's focus on OECHR. So there was an OECHR investigation on Sri Lanka. And what will not happen now we went a step further, as also Stephen Rapp said, and this is great for the fight on accountability and against impunity in Sri Lanka. The thing is that, of course, in this case, we will not have a general call for submissions as the OECHR investigation did at the time, but there will be more targeted collection of information given the nature of the work. And then I just want to reiterate, because we of course hear all the concerns about creating an environment in Sri Lanka where people can securely and safely provide information and evidence. Is that, of course, the project will undertake an overall risk assessment to ensure that victims and their families are not placed at undue risk. So this is really an important part of how the team will conduct this work. Thanks again. And as we said, so you will have the general email address for the Sri Lanka Accountability Project team, and feel free to contact the team with any questions you may have. Thanks a lot again.
Thank you, Livia. Anna, do you want to add anything?
Thank you very much. No, we've consolidated our responses. Thanks so much.
Thank you very much. So just some some issues that have been raised. I think witness protection was something that Anandiyaka raised both inside and, of course, outside the country, and it's something we need to pay attention to. And I really want to apologize to all of the people who were posing questions and who wanted to speak. That time didn't really permit for us to do that. Somebody also raised the question of similar translation, and that was very difficult to organize in the time, but it's something that we will keep in mind, because as you know, the ITJP puts all of its material out in both English, of course, Tamil and Sinhala, and the suggestion has been made that we actually, when we do the recording, to try and deal with that. So we will have a discussion around that. In terms of the link for the recording, the FHR will release that, and we'll find a way of circulating it to all of you. So let me, I think, thank all of you for participating, but in particular our speakers. Steve, I think your willingness and your inspiration is, I think, something that inspires all of us. I'm not sure where you find the energy to crisscross the world in which you do, but your attention to dealing with victims is incredible. And for that, we need to thank you. Priya as well, your ongoing work around these issues, of course, your own expertise in setting up many of the protocols for the IIIM for Syria is going to be very useful, and I hope that there can be some sharing and exchanges with the Accountability Project as well. Amanda and Pablo unfortunately have had to leave to go to another meeting. I think you noticed we ran horribly over time, and I think that's a lesson for us. Tissa, I think incredibly important points that you've made that I think all of us have really listened to and taken to heart. And I think given your own personal experiences of at the hands of, you know, successive regimes, I think is quite critical. And that really shows in the kind of responses that have been made. And of course, to Anna and Livia, thank you for participating in this webinar. I think it's really important as we go forward that we are able to open up a channel of communication to yourselves, because as you can see, there's an enormous amount of interest in it, and critical that we sort that out. To Pablo and Amanda, I think lots of questions for them, lots of comments from MPs, Tamil MPs from across the world, too many to kind of put into the process now. But I think what we will do is make sure that all of the questions are circulated to all of you and the comments as well. And then, of course, to the JDS, to the FHR, and to our media people, Sophie and Molly, thank you very much for organizing this. It was a wonderful opportunity, but obviously something that we need to repeat again and perhaps have another conversation in another few months. So thank you very much, all of you, for being part of this event. Any final housekeeping comments, Francis? Not. Thank you. So we will check out. Bye.
Mm.